this afternoon. We also have a Dean at Akron Law, those who may leave, but Dr. Weather, and I'd like to speak to you for a moment. Dean Matt Wilson.
I just wanted to take a few seconds, literally 30, and welcome all of you out to the University of Akron School of Law on a Friday afternoon. It's great to see so many of you for such an exciting event. We're so happy to have a distinguished visitor from north of the border in Canada, one of my colleagues and compatriots in terms of a dean of a law school that is here to talk to you today about something of wonderful interest. So we would like to thank Paul and taking the time for coming down. We would like to thank all of you for your time, and we hope to continue to have many events like this. We'd also like to thank the Becker Center and all of the wonderful things that they do here in the state in terms of ethics and the profession of law as well. So with that, I'll turn the time over to one of our own professors, the distinguished Professor Jack Saul, and he will introduce our speaker of the day.
To make sure my wife is applauding. But you know, one of the things that Dean said very good, and I just want to reiterate this because Frank and I want to thank all of you. I've recognized a couple of faces from prior symposia, and this center has got a national, if not international, reputation, and in part it's due to the kind support that you offer by showing up and hearing some very good lectures, and so we want to continue to do that, and we hope you can continue to join us. I'm going to read a little bit about Paul Payton, Dean Payton's background, because it's voluminous. I've tried to pare it down, but there's some really important things I think you need to know. And I'm a bit biased because I've known Paul now for at least 15 years, and we work in the same field, and he's a wonderful person. But more importantly, he was just recently appointed Dean of Alberta Law School, which is, I think, the #2 law school in Canada, very well known north of the border and elsewhere. And he's also the Wilbur Fee Becker Professor of Law at that university. Before he went there, he was a professor at George Law School in California, and he was also the Professor of Law and Director of the Ethics Across the Professions Initiative at that law school. And if that wasn't enough, he decided at one point to also take a brief stint as Vice Provost of that university, in which he was really overseeing 3 different campuses. He, in terms of his involvement with the American Bar Association, has just been outstanding. His most notable accomplishment has been as reporter, appointed in 2010 to the Ethics 2020 Commission, which came out with its report about a year ago. And he was the reporter for the Alternative Business Structures group. And I know he worked very hard on that. Some of that theme and some of his thoughts will certainly percolate into this discussion today. Prior to that, too, he was also a faculty member at Queen's University in Canada, and was also chair of the Canadian Bar Association National Ethics and Professional Responsibility Committee for 2 years. He's lectured not only across this country, but certainly Far East and Europe. He holds an undergraduate degree, a law degree from the University of Toronto, a Master's of Philosophy in International Relations from Cambridge, and a Master's and doctoral degree in law from Stanford. But more importantly, I think from my point of view, when it comes to talking about ethics, this is somebody who's actually practiced law out there. He was a commercial litigation partner in a major firm in Toronto, I believe, right? I think they have offices elsewhere. He also worked in the general counsel's office for Price Waterhouse Cooper, and then he also served as an advisor on law and justice issues to the Premier of Ontario. So, you know, Paul brings a wealth of information and experience to this field. He's on the cutting edge. People are looking to him as we speak. He's got engagements going on, trying to give us some idea about what's coming down the pike in terms of changes in the delivery of legal services and also in the law school world. And I would certainly not be doing him justice knowing how hard he writes in his kindness in looking at stuff that I work on from time to time. He's also author of a very prominent ethics textbook, co-author, Global Issues in Legal Ethics, published by West. And he also received a Distinguished Service Award from the Ontario Bar Association recently in 2002. So with that, welcome, Paul.
Jack. Are we good to go? Are we good to go? Testing 1, 2. Abandoned technology. Are we good now? Is that better? You can hear me in the back.
Just a
Little art. Okay. Good. There you go. Excellent. Good afternoon. There goes your opportunity for a nap at 4 afternoon. Although I could put that. I also have written something recently on lawyers and mindfulness and getting into the space and zone and taking your couple of minutes for quiet contemplation. I will not suggest that we do that right now at the beginning of the lecture. It's terrific to be with you. I have really enjoyed this visit, and I'm very grateful to Jack and to Frank and to the Miller Becker Center for Professional Responsibility for the work that you have done for a decade in advancing and promoting ethics and professionalism in the legal profession. I hope you all appreciate what a gem of a center that you have here, because the impact of the center in legal ethics academic circles across North America and internationally far outstrips some of the recognition that you will have had otherwise because of the efforts of people like Frank and Jack and all of you in supporting the work of the center with the Akron Law Review publishing papers from the symposia, rebroadcast and otherwise. This is a center of major importance in terms of not only facilitating the dialogue about what's happening right now in the legal profession, but what's coming down the pipe and how lawyers can be prepared now and into the future to face not only the economic changes that I'm going to be talking about, but the ethical changes and responsibilities that are concomitant with being a professional. So it's to your credit. I know that as a fellow new dean, I'm learning a lot about my own institution and its history. Dean Wilson, you have a terrific program here to be supported and continued, and I think the turnout this afternoon certainly reflects that. So congratulations to you and to the Akron Law School, as well as to the center. When I talk about the future of legal services and the death of big law, one of the things that has troubled me in the conversations over the last few years, and I want to take the next 50 minutes to talk about some of the issues that have really been facing the profession in a time of profound challenge and change. But one of the things that's concerned me fundamentally is the absence of small firms and small practices from the dialogue. I'll talk a little bit about the Ethics 2020 process, the decisions that were made or not made here in the United States to amend the model rules of professional conduct to permit new forms or alternative business structures for the delivery of legal services. I'll speak a little bit about what's happening in Australia, the United Kingdom, and in Canada, because they may portend what you will see here in the United States. But one of the issues and the concerns for me fundamentally in the American dialogue has been that it's largely been about big firms. And this goes back to some of the work that I started engaging back in 1998 on the question of multidisciplinary practice. The old MDP discussion was fundamentally based around controversy in terms of the ways in which law firms could engage with accounting firms and provide essentially a one-stop shop for the delivery of legal services. And the hijacking of that debate and discussion at the ABA, notwithstanding the recommendations of a commission on multidisciplinary practice, really signaled 10 years ahead of Ethics 2020 what the likely outcome was going to be in terms of a discussion around, again, different ways of delivering legal services. Fred Urey, who is a chair of the ABA Standing Committee on Professionalism, former president of the National Conference of Bar Presidents, and former president of the Connecticut Bar Association, was a member of the commission really focused on the interests of small firms. And he wrote a very provocative article published by the ABA Center for Professional Responsibility earlier this spring, and I actually want to start with a quotation from it, because I think it sets the stage for the dialogue I want to engage in my short time with you this afternoon. Fred said this: "The time is overdue for lawyers to think deeply about what the legal profession will look like in 5 and 10 years. Unfortunately, the fact of the matter is that our present business model is dead or dying. The facts on the ground are telling us what we already know but don't want to admit because our profession is afraid of disruptive change. Our collective unwillingness to engage on unavoidable issues such as non-lawyer ownership, the inability of much of the population to afford legal representation, and a rapidly changing landscape in the practice of law have made us our own worst enemy." Them's fighting words. But what Fred is trying to do is provoke a discussion that did not happen for 2 years that I served as reporter at Ethics 2020, and that largely did not happen for a decade in the aftermath of the decision on the Commission on Multidisciplinary Practice. When you think about almost any other business, and you talk about disruptive change and innovation, you see models being brought forward with timelines and timeframes that are measured in months, not decades. When we looked at, and I spent some time reviewing again Walter Isaacson's biography of Steve Jobs, which I recommend to you. Steve Jobs himself was perhaps, well, not the paragon of virtue or the nicest person. We'll see whether or not they manage to make much of that when the movie comes out. And I was fascinated by the human frailties, but I was more intrigued by the approach that Jobs took to Apple's business that I think offers some important perspectives on the future delivery of legal services. First off, he did no market research in the usual way. With apologies to all of you who are heavily engrossed in empirical research, and I know some of my academic colleagues are, Jobs didn't canvass whether or not there was particular demand for products or services. He didn't hold focus groups, he didn't pay consultants to conduct qualitative or quantitative evaluations of whether or not something was needed, or whether something old could be delivered in a new way. He went on his gut and his remarkable sense of how something could be packaged and sold, not compromising on the product itself or on the integrity of what was being delivered, and not limiting his imagination to what was already in the marketplace. Instead, what he did was create a space where none existed before and then filled it, taking an entrepreneurial risk that his hunches were going to be correct. So those of you who invested in Apple shares, I know it's been bouncing around a little bit in the last month and change, did really well if you actually believed in him, although there was a really difficult period. But if you think about your own usage of technology, did you know you needed an iPad? When we think about legal services, and we talk about access to justice, there are some fundamental problems that are parallel to the ways in which Apple's developed its products. First off, there is no really good evaluation. I mean, there are statistics done and studies done time and time and time again that prove that people do not access legal services in the way that they need to. And we have a very strong sense of that. What we don't have, though, is a very strong sense of the market need for Mr. and Mrs. Middle Class who don't know they need legal services usually until it's too late. We haven't permitted product development in the same sort of way. We haven't thought about, until very recently, the ways in which you can harness technology to not only deliver services differently, but to actually create the services themselves. So we've got this kind of strange contradiction that in every other business market, we have a sense of need and an entrepreneurial risk being taken to develop product to get it to marketplace. And yet, when it comes to legal services, we are fundamentally trapped in a business model that dates back to the 1800s, if not the 1900s. If you think, and I was talking to 4 classes here yesterday, about the ways in which a law, if you think about a law firm, what does it look like? Pretty much bricks and mortar, although there are some developments in virtual law firms. You have a lawyer, maybe a senior partner, somebody we're in a reporting associate partner relationship. You might have a paralegal. You may have a secretary, although that's actually changing dramatically as well. The typewriters are replaced by a computer. As one of the students pointed out, there's still lots of paper files in most of them. We haven't gone completely virtual yet. And it looks very much like a model for the delivery of legal services that dated back 10 years, 15 years, 20 years, 50 years, 100 years. And so at a time of transformation and change, when we're thinking about access to justice, alternative business structures, and the manner in which the legal profession has to confront the fundamental gap between need and the ability to satisfy it, it's time for some creative thinking. And so Fred Urey is actually calling a spade and saying, we're too afraid to confront change. Or we're too afraid of the potential disruption to our traditional business model to really tackle the fundamental problems that are posed ethically and otherwise by some of these new developments. So in that respect, I want to take you on a little historical tour, starting with the death of Big Law, which was actually a 2009 article by Larry Ribstein that shook things up quite dramatically in terms of the dialogue and the discussion about the ways in which legal services were being delivered by large law firms in the United States and elsewhere. In the aftermath of the economic downturn of 2008, Ribstein's conclusion was that large law firms had faced unprecedented stress, but that events in terms of the economic challenges, some of the law firm bankruptcies and otherwise, actually reflected more than just a shrinking economy. Instead, and I quote, "The basic business model of the large US law firm is failing and needs fundamental restructuring." He set out 3 prerequisites to establishing a viable large legal services firm for the future. First, he said the firm must own a core of durable, firm-specific property. Slightly radical change, but the fact that the firm would own durable, firm-specific property was something that a lot of the large firms weren't following. Second, he said, and this becomes more important as we look at alternative business structures, the firm has to be able to secure non-lawyer financing in various forms. Those of you in the back, that was not your invitation to nap. I did tell you I'd work a break in there somewhere. So securing non-lawyer financing in various forms was the second prerequisite. And third, he said, and perhaps most importantly for lawyer regulation, a coherent legal structure must evolve that is suitable for large law firms. He concluded Big Law's ability to meet these conditions is contingent upon significant change in the regulation of law practice. Well, so far we haven't seen that fundamental change here in the United States. And in Canada, it largely also hasn't come, although there are some potential developments on the horizon that may end up shifting focus. He also articulated back in 2009 a few other features. Decreased demand for legal services, at least from those large firms. Reduced information asymmetry. People are much more informed about the legal services that they're getting and the ability to compare products and services and the competition in the profession. Third, he talked about declining reputation and declining quality, that there were stresses on that for all the big firms as a result of the economic pressures to deliver faster, cheaper, and more profitably. He talked about increasing global competition, a deprofessionalization, as he called it, of law practice, the decline of hourly billing, and his final conclusion was a devolution of the firm, that control was becoming more disparate, and that the traditional firm model was irretrievably broken. Well, a lot of focus and a lot of paper and a lot of academic studies were spent in the last 5 years deconstructing RIBSTE, agreeing, disagreeing, rejecting, or otherwise. And I thought it quite interesting that there was a special report in the American Lawyer as of October 29th, so this is just fresh off the presses, called Big Law's Reality Check. Last year, the AmLaw 200 set new records for gross revenue, profits, and revenue per lawyer. On all fronts, the firms blew past the peaks they reached during the boom years when ominous signals were just something to ignore. So in that respect, at least, the developments in terms of the problems for big law are still there. There are some fundamental pressures. I'm not discounting those. But to me, it's time to shift the emphasis in the public discussion and the debate to where most real Americans, most real Canadians, most real Brits, most real Aussies will access their legal services. And that's from small and medium-sized firms and individual practitioners who are the backbone of service provision for legal services in all 4 of those jurisdictions. We have not had enough of a dialogue yet about the impact of alternative business structures and freeing up or liberalizing the means by which they're able to deliver legal services and the impact on those small firms, and more importantly, on the consumers who are accessing them. And this is part of a problem that Fred Urey points to in his article earlier this year and in most of the speaking that he does. Because in all of the dialogue and the debate, it's lawyers talking to lawyers. For those students in some of the classes yesterday, you'll recall that I talked about how we as lawyers think. We rely on precedent. We spend a lot of time in the rearview mirror. We look at what's worked in the past, not necessarily what needs to happen going forward. And so if you're looking for, with perhaps the exception of certain notable students in one of the classes I was in on entrepreneurship, we aren't necessarily taking an entrepreneurial approach in law schools or in legal education as to how our students are going to not only survive but thrive when it comes to things moving forward. So that's where the story gets interesting for me. And small firms are in many respects and in many jurisdictions in trouble. But there are opportunities for change. And I think those changes are coming fast and furious. And while it may be a real challenge for many of them to continue to survive, if we afford the opportunity for those small firms to innovate, to create new ways of going to market, look at new ways to get financing, look at new ways to access profits, then we at least have the hope that not only they will continue to survive, but the consumers who are so desperately needing access to legal services will be able to get them faster, cheaper, better, and more conveniently. I've been known as a bit of a heretic from time to time because I dare talk about legal services occasionally as product. Those are fighting words to those who are concerned about professionalism. And please know that after a decade plus in the academy, now as dean of a law school, and throughout my legal career, I am no less concerned about ethics and professional responsibility issues as they relate to these questions. And so there are 3 fundamental concerns that have been addressed in the United States, in Canada, Australia, and England, as people are looking at this question of how do we liberate the traditional structure for the delivery of legal services? Well, in the United States, those of you who have come through the NPRE will be very familiar with 5.4. Thou shalt not share fees with a non-lawyer. Period, full stop. And in that respect, at least, that impediment to creativity is what animated the multidisciplinary practice debate of over a decade ago. The more recent discussion at the ABA's Ethics 2020 Commission, and now with the release of an issues paper this week, the new ABA Commission on the Future of Legal Services. Why can't we share fees with non-lawyers? Or what restrictions need to be put in place in order to ensure that doing so accords with our ethical concerns about privilege and confidentiality, about the independence of the legal opinion, and about the way in which we comport ourselves as professionals. Because those concerns don't die away, and yet those lawless, those hopelessly lawless jurisdictions, England and Australia, have somehow managed to figure out certain ways forward. So let me take you on a quick tour of what some of these developments are. Well, in the United States, the Ethics 2020 Commission that I worked for, and some of the materials are provided and available and summarized for those of you who have gotten the small articles. The commission asked me to actually support, first off, a group called the Alternative Business Structures and Entity Regulation Working Group. You'll notice that Professor Saul didn't mention entity regulation. That got dropped almost as quickly as the working group got started. Because the idea that we would somehow regulate the firm was anathema to over 100 years of tradition. One of the interesting developments in Australia has been law firm regulation. And it's actually proactive and kind of prophylactic. The idea that it's a kind of comply or explain sort of model, the idea that every year you have to, as an individual firm, whether small, medium, or large, indicate to the regulator how you are in compliance with best practices by way of a checklist. May seem offensive to certain sensibilities here, but Christine Parker and other Australian researchers have already had proof. Susan Sav-Fortney out of Hofstra now has done an American study with some of the Australians about this, that suggests that that kind of protocol leads to fewer disciplinary cases and better access to services and better disciplinary results, or at least fewer complaints from clients. So how do we improve small law firm practice? Well, we have to regulate the firm, not just the individual lawyers in it. England and Australia, largely both driven by government, fundamentally transformed the availability of structures through which to practice law, not because of pressure from the legal profession to do so, but rather because of pressure from a public that said they're not being served. In Australia, New South Wales since 2000 has permitted full incorporation of law practices. Other Australian territories and states have implemented similar reforms. Legal practices may now incorporate under ordinary corporate law without any restrictions on who may own shares or what type of business can be carried on. For many in the United States, that's a step too far. The idea that you could go to the Australian Stock Exchange and actually buy shares in Slater & Gordon, the major law firm, seems just out of this world. How can you possibly reconcile all of those issues that arise ethically with the idea of owning shares in a publicly traded law firm? Well, it happened. In May 2007, Slater & Gordon became the first firm to be listed on the Australian Stock Exchange. It now employs 1,350 people in 69 locations with a focus on personal injury and class action on the plaintiff's side. What have they used the funds to do? Remember that Larry Ripstein talked about big law needing to rethink the ways in which it actually financed itself. Well, what have they done? They've gone to the public market to get funds to allow innovation in a few different ways. One, they expanded their operations. Small law firms are, again, in terms of economic models and economic consolidation, I defer to those of you who are the econometrics experts in the crowd. But in terms of the ways in which the economic models work, there's a certain inefficiency to individual practitioners having to be their own IT department, their own marketing department, their own promotion department, to be their own bookkeepers, to do everything themselves. And so in that respect, at least, what Slater & Gordon has said to a number of plaintiff personal injury firms, join us. We can take care of all of that for you. You will come under a reputed brand. You will still be able to, and you'll actually more be able to, focus on practicing law with no compromised ability to serve your clients, and in fact, better access to the resources that you need to serve more of them better. May not be the model for everybody, but it's one that's worked. You've had a regulatory system that's also based fundamentally now on entity regulation rather than on the individual practitioner. And there were changes to the Legal Profession Act in 2004 and the Legal Profession Regulations in 2005 to encourage firms to complete annual voluntary self-assessments about the ethical and management responsibilities. Here's the change. It's annual and it's voluntary, not mandatory. But most firms actually find that the moral suasion of being required to explain why they wouldn't comply motivates a certain particular behavior going forward. And instead of being prescriptive, it's outcomes-based. How are you actually making sure that your results are more positive in terms of decreased numbers of complaints, better responses from clients in terms of how much are you communicating with them, better quality notionally in terms of what clients perceive of the service. And so when we're looking at disciplinary models for the ways in which lawyers are practicing disproportionately in other jurisdictions, and I haven't studied Ohio, the disciplinary complaints arise and are dealt with small practitioners and small firms. These are the folks who get themselves into trouble when the finances get hard and they dip into the trust funds. Or they're strapped, as they were in California after the economic downturn, and came under considerable pressure from clients to actually give the opinions that the client wanted, rather than the independent legal advice that they should have been providing. Mortgage assistance or mortgage renegotiation was a fundamental problem for the California State Bar for a whole bunch of new graduates who were being unleashed on the profession into the worst economic downturn in at least 40 to 50 years. So maybe the Australians have something when it comes to firm regulation. And if stock market listing goes too far for you, well, there are other models, but the fundamental question that has come up in that kind of context is, how do we actually get lawyers the resources that they need to innovate? And this is where the alternative business structure and the sharing of fees with non-lawyers in different and creative ways may end up actually resulting in the fundamental change. So if Australia is a little too radical, England and Wales may be a better option for you. And the history of developments in England and Wales actually dates back well over a decade plus, across flavors of government that range from Margaret Thatcher's conservatism to Tony Blair's Labour government and every stripe in between. This was not a politically motivated, ideologically politically motivated shift, but rather one that came up as a result, in my view, of a 2001 report from the Office of Fair Trading, their essential Bureau of Competition, or antitrust office, that said, we need more competition in the professions because the consumers are not being well served. And law society, lawyers, if you don't do this within the context of your self-regulating profession, we will come in and do it for you. So in my view, both in Australia and in England, although some disagree with me, the impetus for change was not from the profession itself. It wasn't even from organized consumer groups necessarily. It was from government that was saying, we have a population that is dealing with unmet legal needs, a system and a structure that's broken, and restrictions on innovation that we've imposed in no other industry. So it's time for that change. July 2003, Sir David Clementi was appointed to carry out an independent review of the regulatory framework for legal services in England and Wales. They had a whole host of other problems. You had 7 different regulatory bodies, depending on the kinds of legal services that were being provided. You have barristers, you have solicitors, you have conveyancers, you have others, where in terms of their regulatory model, they had their problems. But more fundamentally, the legislative change in the Legal Services Act in 2007 set out a number of principles under which the delivery of legal services ought to be regulated. And horror of horrors, ensuring the interests of protecting consumers was one of those regulatory objectives. This was not something that you'll often see lawyers talking about when it comes to regulating others. Yes, protection of the public, but the conflation often of the rhetoric around protecting the public interest with protecting the guild's self-interest economically is a fundamental problem. We're pretty good about talking a good game when it comes to all of that, but when it is about blowing the market open and making sure that we compete, well, not so much. So in England, government threatened to do this for the legal profession. All sorts of changes resulted under the Legal Services Act in 2007. Protection of the public, improving access to justice were two of the other fundamental principles. But promoting consumer interests and promoting competition is right in the legislation. There are now 8 separate approved regulators, which is a problem. And you have the creation of different entities that support what are called ABSs, alternative business structures. And the models for alternative business structures are different. But in one case, where you are a solicitor doing traditional, what we would consider sort of corporate non-litigation work, that's regulated by the solicitor's regulatory authority. If you want to apply to be an ABS, you have to provide the firm's regulatory history, the type of legal work to be conducted. You have to map out your business practices, including your policies and procedures, your proposals to meet these regulatory objectives, your proposed governance structure, details of personnel, your indemnity insurance, how you handle clients' money, and what they call a suitability declaration, which basically is a self-assurance from the firm that both the solicitors and the non-lawyers who are members of that alternative business structure or owners in it are satisfactory in terms of the equivalent of a moral character determination. What does that allow? Well, so far at least, you've had different sizes, structures, and expertise. The most recent information that I had from the Solicitor's Regulatory Authority came this summer. You had, as of June, 308 of these structures being approved. You have over 5,000 law firms in the UK, so we're still not talking a huge percentage of the marketplace. But in a year and a half, it shows that there's some interest. The ways in which the Solicitor's Regulatory Authority is talking about impact so far is that first off, ABS has accounted for 1/3 of all files in the personal injury market and have captured a significant portion of the work in mental health, consumer, social, and non-litigation law, as they describe it. What was the reason these traditional firms converted to ABS? Financing. What they wanted to be able to do was access resources in a way that didn't just require capital contributions from their partners, but wanted to make some of their non-lawyer employees and others members of the enterprise. The risk-reward calculus is there. I can't afford individually to hire the technology services, but maybe somebody providing IT support wants to take a portion of the action. Be invested in the future of this company. Now, for lawyers, this is a radical shift. If you're in the Silicon Valley or elsewhere talking to venture capitalists, this is nothing strange. But there are important ethical protections that the SRA has put into place, and so far at least, there have been virtually no complaints. It's still early days. What's also interesting and what's important for purposes of our discussion, I think in particular, and this focus on the future of the small firm, is that so far at least, 85% of those firms converting to become ABSs are small firms of fewer than 10 lawyers. So this isn't the big players. It's not, the big law firms that are engaging at this, at least so far. It's what they call the high street firms, what we would call the main street firms, who are saying we can do services in a slightly different way, and there are also all sorts of different models. The others who are becoming ABSs, and this is where it's also an interesting parallel to, I think, what might end up happening here, are some of the consumer-facing entities like the cooperative, like Tesco grocery store. Basically, that would be like a Safeway or a Kroger's. You have the Automobile Association announcing a year ago, November, that in addition to being able to go in to purchase your automobile insurance, to get your maps, to maybe renew your driver's license, you can now get your will and estate planning done. One of the biggest distributors of legal services is a kiosk through W.H. Smith bookstores. You also have quality solicitors, which is essentially a franchise model. They say to individual lawyers, you know what, we will do all that back office stuff. You're not delivering pizza, you're delivering legal services, but in terms of the marketing, promotion, branding, reliability, we will take care of all of that for you. And there's an evaluation that gets done of the individual practitioners who are applying to be members of quality solicitors. Why? Because they've got a vested interest in making sure that they uphold the brand. This seems radical, but for most consumers, if I'm going into Costco, I'm not necessarily, well, as I'm buying my vat of mayonnaise, more hot dogs than I will ever need, and every roll of toilet paper, it seems, known to mankind, getting legal services may seem not necessarily something I have on my mind. But some of the evaluations and some of the studies about consumers in the UK is also really instructive, I think, for, frankly, research work that needs to be done here in North America. When they surveyed people, do you think it's a good idea to have a will? Over 70% of them said yes. When they surveyed those same people, do you have a will? Fewer than 70% of them did. And most people, in terms of that basic planning, haven't engaged in. So there's a market opportunity that we're not filling. So ABSs are still in their early days in the UK, and we'll see what ends up happening in that regard. I was invited across by the Law Society of England and Wales a year ago, November, to talk to them about some of the developments in North America and some of the opposition from the American Bar Association Commission on Ethics 2020. And I was at a Legal Futures conference. And what was interesting to me, yes, the presentations on stage were remotely interesting. But what was more interesting to me was who was in the audience. Google was there. Deloitte's were there. A bunch of venture capitalists were there. So people are circling around this space with great interest. Why? Well, this came up in the discussion with the students yesterday. Lawyers and others are looking at ways to serve that market without actually making it the provision of legal services. How many of you have heard of LegalZoom? Okay, vast majority. Shows the power of advertising, doesn't it? If you see Robert Shapiro on TV talking about meeting your needs and going with a click of a button or a click of a mouse, if you still have a mouse, and downloading a form or filling out a form online for $20 for a promissory note, I've said, that might do you really well in Arkansas. But in terms of actually meeting your legal services needs, it's not there. However, where's the proof that there is a market for all of this? LegalZoom was prepared to go. They filed an S1 with Securities and Exchange Commission to raise $120 million in a public offering to supplement and support their financing needs to expand their operations. That was a year ago May. They pulled the financing. Why? They got it through private equity. And so if you look at the ways in which they see a market need and demand, what I find really interesting is that they're focusing not on the big firms. They're not focusing on trying to replace the White Cases of the world. They're not looking at an international marketplace. They're looking at consumer needs in small town middle America that lawyers somehow are not getting to. Why? Why are we not actually accessing that marketplace? We're not experts in marketing and branding, that's to be sure. Do a separate presentation. I've had separate presentations on lawyer advertising. This is a wonderful study. There are lots of things online about it. But you take most lawyer ads, substitute the name of any other firm or any other lawyer through it, and they will all look the same. Mentioned yesterday to one of the groups, if you're looking for a personal injury firm and watching television ads, every city that I've ever been to in America has an ad for the heavy hitters, which are usually the same music. They're not all part of the same firm. We're not doing a good job of explaining to people as well, I think even more importantly, what the value is in hiring a lawyer. And so LegalZoom's $20 promissory note looks really good. Does it do what I need? Well, it returns my phone calls. I have the instant access to it. It's non-threatening because I can access it from home. It's familiar to me. I've seen the ads. It seems to be providing some value at a price that I understand. Folks, these are basic business propositions that we've ignored at our peril, that are imperiling the ways in which small and medium-sized practitioners are able to access the market. Okay, so we've got the Australian experience, which is fairly radical. The English experience, which is still, as I've called it, a living laboratory. We'll see where it goes. I mean, with 308 entities, it's a bit of a hard test case so far, but that's still developing. What about Canada? 2 studies so far, at least, might be changing the game. The Canadian Bar Association issued a Futures Task Force report this past August that covered everything from changes to legal education to alternative business structures. And it recommended an overhaul and a liberalization of the economic model and the rules and the regulations that preclude lawyers from both partnering with other professionals, so the multidisciplinary practice model, making it a full-blown MDP with true equality between the partners, not just a law firm plus, and yes, you can make an accountant your partner as long as it's only one. And the potential for more is certainly there. But, and this is an important but, that was a discussion paper issued by the Canadian Bar Association. It will be coming up for a vote at the Canadian Bar Association's midwinter meeting next February. And already, the drums are beating, just as they did in the United States around ethics 2020, that there is no way that this is going to pass. Why? Because it would fundamentally transform and threaten, provide that disruptive change that Fred Urey was talking about. So we don't like change, necessarily. Even our own bar associations aren't necessarily, they're coming out with these reports and then we're voting them down. So what about the regulators? In Canada, the Law Society of Upper Canada regulates the province of Ontario. Law Society of British Columbia does the same out on the West Coast. Each province has its own. Law Society of Upper Canada has had now a discussion and a debate about alternative business structures for about a year and a half. They issued a discussion paper on top of their previous discussion paper, on top of their symposium report, all of which basically said this needs to change and be liberalized. The Law Society of Upper Canada's benchers, or governors, are lawyers primarily, who are elected by the legal profession. There is an election happening next spring. What do you think is happening to the report that just got issued? One of its co-chairs, who's a colleague and a friend, was on a panel with me at the Ontario Bar Association's conference on professionalism in the legal profession for in-house counsel last week, and noted basically we won't be promoting this a whole lot more right now because there's an election campaign going on. And you know what the opposition is to alternative business structures? Everywhere this is a litmus test for whether or not lawyers are prepared to accept change. So briefly then, the story of 2020, and more importantly, the ABA's Commission on the Future of Legal Services. Ethics 2020 was set up to study, as the ABA does about every 10 years, needed reforms to the model rules of professional conduct, and in particular, then ABA President Carolyn Lam in 2009 said we need to be cognizant of 2 primary forces for change: globalization and technology. What are they doing to transform our profession? She also said, though, we need to take a look, because of what's happening in England and Australia, markets in which American lawyers are competing, to see what benefits and challenges are there for our lawyers trying to compete, and what ideas we need to actually make sure that our lawyers have access to in order to be able to better serve clients here in America. Thus, the creation of the Alternative Business Structures and Entity Regulation Working Group. Oops, we'll change the name. It became the Alternative Legal Practice Structures Working Group, or ALPS, which became a mountain too high. For those who were actually trying to effect change, there was no stomach at the ABA's council for any reform. There were 5 different possibilities that were explored, at least initially in the discussion paper that was put out. 3 of them were rejected before they ever even got to the commission. One model was a variation, minor variation, on a model that's been in place in the District of Columbia for over 20 years. Even that went nowhere. And so again, I go back to England and Australia, and what affected change? A signal from government that we will do this for you if you don't do it yourselves. So we now have the ABA's Commission on the Future of Legal Services, and all sorts of discussion happening again about alternative business structures, the ways in which technology and innovation and financing are going to change the ways in which people are accessing and delivering legal services. And so the ABS dialogue is going to happen again, but there's a slight change this time. Because those lawyers who are members of small and medium-sized practices are starting, in my view, to recognize that this might be in their self-interest. And you know, enlightened self-interest tends to be the best animator of policy change that I've ever seen in any kind of political or university environment. So there may be hope yet. And in that respect, what's it going to take? First off, I think we need some answers. We need some answers to the fundamental ethical questions. First off, how do we ensure that client confidences are protected when we have non-lawyer owners? How do we make sure if Costco is actually financing my business model and needs information from me to continue that financing, that I can provide that information adequately scrubbed so that my client's interests are protected, and yet at the same time I can continue to secure the financing for my primary backer? You'll note that I haven't used the expression Walmart law, but it's coming. 3 weeks after I was appointed dean in Canada and had done a number of interviews back in March about the future of legal services, guess who opened a set of kiosks in the Canadian marketplace with a franchise provider of legal services? Walmart. Folks, they're in this game already. And they're taking a look very seriously. Why? Because people trust the brand. So how they're dealing with these ethical problems will be an issue for investigation as we end up moving forward. What about independence? I've used the illustration previously of some of the major US firms that collapsed because their lenders pulled their funding, or ended up imposing such restrictive terms and covenants in their lending agreements that essentially what the lender was doing was controlling the way in which the law firm could do its business. I don't see how that's different. If a bank's dictating to me how I can practice, and that's permitted right now, I don't see how that's much different from outside investors having certain interests in particular directions that I'm going to take my firm, and that I have to justify to them in terms of my business plan and proposal. We may need to get more creative about how we finance. We may need to harness technology and innovate in ways in which every other industry has done it. But we can't say that these ethical problems, privilege and confidentiality, independence, or any of the other roster, conflicts of interest being another, can be an impediment to us affecting change. If we want to find solutions, we will. But what that requires is for us to focus first and foremost on the consumer interest. And ladies and gentlemen, we've got an access to justice problem. Not only from those who are falling below the federal poverty guidelines, but from many in the middle class who will face dramatic legal consequences, whether it's in family law, in criminal circumstances, whether they're small businesses or otherwise, who can't afford legal services right now, who LegalZoom are trying to reach to, and end up in front of these situations as self-represented litigants or self-represented claimants. That's a problem for our system. It's a problem for public confidence in the administration of justice, and it's a problem we've not done a really good job at addressing. But it's a bright future. And I think the entrepreneurial energy that is in this student body, is in my student body, is in law schools across America, can be harnessed for good. I don't know what app you will develop that will be both ethical and make you very wealthy, but I hope it comes. Why? Because I think we need to talk about at least ways in which we can innovate to solve some of these problems. So yes, people have been concerned about the death of big law. And there will be a lot of people continuing to focus on the death of big law, notwithstanding the evidence that I just provided you from American Lawyer that big law seems to be doing just fine. But for the small and medium practitioners, and for those who are consumers in small and rural communities, there are real problems that we need to address right now, and I'm hoping that those in Canada and the United States who are engaged in this problem, and indeed all of you, will work forward for some of those solutions that will end up defining the ways in which we both practice law, teach about it, and learn it in the decades ahead. I appreciate the opportunity to be with you this afternoon to talk about some of these ideas. Thank you very much for your attention and for coming.
We have time for about one, maybe two questions. We have an hour to fill here for anyone with questions.
Sure.
Are the provinces doing anything inside the court system to provide more assistance to pro se plaintiffs and defendants?
Hugely controversial issue. And there was a meeting of deputies, attorneys general, and the attorneys general of all of the provinces in Banff, Alberta 2 weeks ago to press the federal government for additional funding for legal aid support. They have not been as creative in terms of the approaches for self-represented litigants, and I spoke to 80 judges last Friday who were looking at questions on judicial specialization. Why? Because of the volume that they were encountering in the courts, not only of cases and caseloads that could perhaps, through process reforms, be managed better, but the ways in which the court system is getting jammed up because of the increase in self-represented litigants, especially in family law. I don't know that I've seen creative solutions from the provinces yet. There are lots of different and small pilot projects in different communities to try and get their representation, but there's been no overarching solution to the problem that I think we're facing in similar but equally challenging ways as is being faced here in the United States.
I think that takes up our hour. And Dean Pat Payton has said that he will be here. If you want to come a moment with him,
I'm happy to continue the conversation. I'm also cognizant very much of the ways in which we measure hours for CLE, so thank you all very much.
have a nice